Hello, everyone, and welcome to the Wills, Women, and Wealth podcast. I'm Elsa W. Smith, your Maryland estate planning and probate attorney, and I'm thrilled to have you with us today. We're here to empower women who value their health, wealth, and the legacies that they're creating. This podcast delves into a diverse range of subjects, encompassing finance, law, mental and physical health, and beyond. Our commitment is to furnish you with invaluable insights, engaging expert interviews, and enlightening episodes that address your questions on wills, estate planning, and probate matters. Remember, this is your community, and we want to hear from you. Engage with us, ask questions, suggest topics. Let's build a dialogue. Reach out on social media or leave a comment. Your input fuels the conversations we have. You can find all our episodes on YouTube, Spotify, and Apple Podcasts. So make sure to subscribe and stay tuned for our upcoming content. We would really appreciate you following the podcast and leaving us a 5-star review. Your 5-star review will amplify the podcast and get it out to more people. Now, on with the podcast. Today's topic is what you need to know: Maryland Intestacy Reform and the Domestic Partnership Registry. To give you a roadmap, we'll cover reforms in the intestate share of the surviving spouse, domestic partners, great-grandparents and their descendants, and finally, changes in terminology. But first, let's define what we mean by intestacy. It's the state of dying without a will. If a person dies without a will, they are said to have died intestate. The estate of a person who has died intestate goes through probate court. The state's intestacy rules will determine who will inherit a decedent's assets. And by the way, when I mention decedent, that is the person who has died. In this part of the podcast, we're going to be discussing a significant shift in Maryland's intestacy laws, particularly focusing on the share allocated to surviving spouses. As of October 1st, 2023, the landscape has evolved, bringing about key changes. Let's explore the nuances of the new law compared to the former one. Under the former law, when a decedent left behind surviving minor children, half of the estate went to the surviving spouse and the other half to the children. But when it comes to surviving adult children who aren't also children of the surviving spouse, the dynamics alter. The surviving spouse used to receive $40,000 plus half of the remainder, with the surviving children getting the other half. Now, fast forward to the new law. If the surviving adult children are not also children of the surviving spouse, the surviving spouse's share increases significantly. It's now $100,000 plus half of the remainder, with the surviving children receiving the other half. This adjustment reflects a substantial shift in the allocation of assets, ensuring the surviving spouse is provided for in a more robust manner. But what if all surviving adult children are children of both the decedent and the surviving spouse? Under the former law, the surviving spouse receives $40,000 plus half of the remainder, shared with the surviving children. However, the new law takes a bold step. In such cases, the surviving spouse now inherits 100% of the estate. Now, let's talk about scenarios with no children but surviving parents. Previously, if the decedent and the surviving spouse were married for less than 5 years, the spouse received $40,000 plus half of the remainder, with surviving parents getting the other half. However, if the marriage lasted at least 5 years, the surviving spouse took 100% of the estate. The new law removes this distinction. Regardless of the duration of the marriage, if there are no children but surviving parents, the surviving spouse inherits 100% of the estate. Are you in Maryland or DC embarking on your estate planning journey? Let us guide you through the process. Join us for a complimentary 15-minute call with a member of our team. There's no obligation. Check out the show notes for the scheduling link. Your first step towards securing your family's future starts here. Our discussion now will shift to address domestic partnerships. As of October 1st, 2023, Maryland has ushered in transformative changes, reshaping how domestic partners are treated in an intestate estate. Let's unpack the evolution from the former law to the present. Under the former law, Maryland had no domestic partnership registry. Surviving domestic partners were treated as legal strangers in intestate estates, facing a complex scenario with limited inheritance tax exemptions. To qualify for an exemption, proof of joint ownership of a primary residence was required. Even then, surviving partners were subject to a 10% inheritance tax on all other assets. It was a situation that often left domestic partners in a legal gray area, lacking the recognition and the benefits afforded to married couples. Now, let's look at the new law as of October 1st, 2023. The game-changing feature is the introduction of a domestic partnership registry managed by the Register of Wills. This registry signifies a crucial step toward recognizing and formalizing domestic partnerships in the eyes of the law. Under the new law, a surviving domestic partner in a registered partnership is now treated on par with a spouse in an intestate estate. This monumental change removes the legal ambiguity that formerly surrounded domestic partnerships, offering equal footing to surviving partners in the absence of a will. Additionally, the limited inheritance tax exemption for jointly owned primary residences remains, but with a significant enhancement. Proof of partnership presented at death still qualifies for the exemption. However, the new law introduces a streamlined process for registered partnerships, automatically qualifying them for this exemption. This change simplifies the procedure, making it more accessible and efficient for surviving partners. Perhaps one of the most noteworthy aspects of the new law is the full exemption from inheritance tax for surviving partners who were in a registered partnership. This means that if you've taken the step to formalize your partnership through registration, you are now fully exempt from inheritance tax on all assets. It's a powerful recognition of the value and commitment inherent in domestic partnerships. So, in summary, Maryland's intestacy laws regarding domestic partnerships have undergone a remarkable transformation, establishing the domestic partnership registry, the equal treatment of surviving partners, and the enhanced inheritance tax exemptions collectively mark a shift towards greater inclusivity and recognition of diverse family structures. Now, let's continue. In this segment, we're going to review the provisions for great-grandparents and their descendants. Under the former law, when there was no surviving spouse, no descendants, no parents, no descendants of parents, no grandparents, nor descendants of grandparents, The heirs next in line to inherit were great-grandparents and their descendants. These individuals, often distant family members, were sometimes unknown to the decedent, adding an extra layer of complexity to the inheritance process. Now let's look at the new law as of October 1st, 2023. In similar scenarios where there is no surviving spouse, again, no descendants, no parents, no descendants of parents, no grandparents, nor descendants of grandparents, the heirs next in line to inherit take a bold shift. Instead of the great-grandparents and their descendants, the new law designates stepchildren as heirs next in line. This change marks a significant departure from the former law's reliance on distant familial connections. By prioritizing stepchildren, the new law recognizes the evolving nature of family structures in today's society. Stepchildren, often integral members of blended families, are now positioned differently in the inheritance hierarchy, reflecting a more inclusive approach to estate distribution. In essence, Maryland's intestacy laws as of October 1st, 2023, are redefining the path of inheritance for great-grandparents and their descendants. The focus has shifted towards acknowledging stepchildren as heirs next in line, a move that aligns with the diverse and dynamic nature of contemporary family relationships. Now let's look at terminology. Under the former law, children born of and not of a marriage were classified as legitimate and illegitimate, respectively. This stigmatizing technology casts a shadow on the diverse ways families come together, perpetuating outdated societal norms. Additionally, the law labeled grandparents as maternal and paternal, tying their identity to gender and potentially reinforcing traditional family roles. Now let's fast forward to the new law as of October 1st, 2023. This groundbreaking change in the law removes the stigmatizing language associated with children born outside of a marriage. The new law simplifies the definition of a child, recognizing and embracing the diversity of family structures. This shift is not just legal, it's a step toward fostering a more inclusive and respectful representation of all children, regardless of their parents' marital status. Furthermore, the new law takes a progressive stance on describing grandparents. Instead of identifying them by gender, the law now refers to first and second set of grandparents. This change moves away from traditional gender-based distinctions, allowing for a more accurate and unbiased representation of family relationships. In essence, Maryland's intestacy laws as of October 1st, 2023, are not just about legal amendments. They're about reshaping the narrative around family and relationships. By removing stigmatizing language and embracing gender-neutral terminology, the law reflects a society that recognizes and celebrates the diverse ways that families come together. As we wrap up, please note that the changes in Maryland's laws regarding terminology, great-grandparents and their descendants, domestic partners, and the intestate share of surviving spouses collectively underscore the importance of estate planning now for several compelling reasons. Estate planning allows individuals to express their specific wishes regarding the distribution of assets and the treatment of family members. With changes in terminology and inheritance rules, having a customized estate plan ensures that your intentions are clearly communicated and legally binding. Well-crafted estate plans can help mitigate potential disputes among heirs. Clear language and explicit instructions reduce the likelihood of misunderstandings or conflicts, particularly when dealing with changes in terminology or alterations in inheritance rules. For individuals in domestic partnerships or with non biological family members, estate planning becomes crucial in providing legal protection. By outlining specific bequests, rights, and responsibilities, you can ensure that your partner or chosen family members are recognized and provided for. Estate planning allows individuals to align their plans with their personal values and beliefs. By specifying the treatment of family members, using inclusive language, and ensuring fairness in asset distribution, individuals can create a legacy that resonates with their values and principles. Remember, estate planning is an ongoing process that can be adapted to future legal changes. Regular reviews and updates to your estate plan ensures that it remains current and effective, allowing you to stay ahead of any future modifications in laws or regulations. In summary, the changes in terminology, inheritance rules, and recognition of diverse family structures underscores the urgency of estate planning now. It empowers individuals to proactively shape their legacy, protect their loved ones, and navigate the complexities of evolving legal frameworks. Estate planning is not only a response to current changes, but a strategic way to prepare for the future. We assist individuals in Maryland and the District of Columbia who are getting started with estate planning, and we can do the same for you. I invite you to schedule a complimentary 15-minute call with a member of our team. There's no obligation, and the link to schedule will be in the show notes. Thanks for joining me on this episode of the Wills, Women, and Wealth podcast. Until next time, this is attorney Elsa W. Smith, your Maryland estate planning and probate attorney. Stay informed, stay empowered, and take control of your legacy.